if we give them this much larger contract, that on day one they're not going to be in a position to compromise another 123,000 Social Security numbers?
I can. The CERCO contract is actually with CMS, and it's called the Eligibility Support Worker Contract. And we've been working with CERCO just recently. They've been awarded. So for the past 2 weeks, we've been ramping up. And one of the top issues that we're going over is the security and their own corporate practices and procedures.
Right, but did you know about these problems and failures before you awarded the contract?
No, I was not a part of the contract award process.
Okay, but now that you know about it, we're working with an entity that apparently does not have the info and major data. Is that correct? So we're working to get a group up to speed that doesn't have a proven track record. My whole question to you is, in the awarding, wouldn't you need an assurance before? I mean, in other words, I'm not saying you couldn't make them ready for prime time in a year or two. The question is, where's the pilot? Where's the proof? Where's the confidence that what has just recently happened won't happen again? You know, I don't normally have something in front of me that says the FBI has this problem and you've got a brand new contract pursuant to Obamacare. Let me just hit one more point. Mr. Werfel, this committee has a broad set of investigations going on related to the organization you're trying to fix, and today is one part of our concern. But you're familiar with the 6103, what it means, is that correct?
Yes, sir.
And 6103 was designed and passed into law to protect the American taxpayer from his or her tax records being looked at by outsiders or released. Is that correct?
Yes.
Was it ever intended to protect from Congress finding out when taxpayers have been abused? In other words, should there ever be a claim of a 6103 when the victim themselves is asking for the release of the information?
Well, I think you're raising a policy question in terms of how 6103 is structured. Right now, it's specifically structured to prevent us from sharing certain information except to the authorizing tax committees. Whether that should be expanded or not, I think, is a public policy discussion on the nature of 6103. But we follow the law, and the law requires us to restrict access except to ways and means.
And I'm going to finish because I'm trying not to go any further over time. The fact is that if we don't know the name and the Social Security number or federal ID of an entity, we don't know their address, that is, and we don't see financial information. That was the intent of 6103. Today, your organization is working to say that, for example, knowing how many groups were waited how long, how many groups are still waiting, those kinds of answers, and whether there is so much as one individual. And I'll give you an example here today. There are the so-called test cases that we've had, 2 test cases. When we ask, is one of them still waiting, and we find out, yes, one of them is still waiting, people are saying, well, and I sent you a letter yesterday with the other chairman and ranking and subcommittee chairman, we're being told, well, that may be 6103. To know that a victim was isolated 3 years ago, pulled aside, and has never been given a yes or no answer, to know that they're still not giving a yes or no answer, the claim that that's 6103 is a claim that, in fact, Congress and the public is not entitled to know that information. And I ask it that way for a reason. I understand another committee can see certain information, but it's the public that's entitled to know, isn't it true that at least one entity that applied more than 2 years ago still does not have a yes or no after the abuse that has become public that we're all aware about as to Patriot and Tea Party organizations?
So 3 quick responses. One, just to reemphasize, we do share the information, but the law restricts us from sharing it only with the chairman of House Ways and Means and the chairman of Senate Finance. Second, 6103 authorize broader disclosure. They can waive their rights, and you can get the taxpayer to say, it's important to make this publicly aware, but I need you to sign something. And respect to, as I've testified before you, I'm concerned about the delay that we've seen in application packages in our exempt organizations unit. And perhaps in a different setting, or whether off the record or on, I can walk you through very important reforms that we're making to our 501c4 process to correct that from ever happening again.
Well, just for the record, if an organization says we'll waive our 501c, the individual records, the IRS's current position is they won't show us the emails where they conspired against or debated that ultimately we don't need to see their records. They can hand us their records. We need to see who at the IRS was delaying and denying and dealing with it. And that's individual emails with specificity as to those 501c4s. Thank you. I yield back.
Ms. Maloney.
Well, thank you. The Chairman raised an important point that a contractor received this contract on very sensitive information, an important one, and according to his words, it doesn't have a proven track record. I want to know how that happened. Don't you look into the backgrounds to make sure they know what they're doing? I'd like to speak to Mr. Cho. And also, I'd like you, Mr. Cho, to also talk about how difficult it is to reconfigure the data hub that you are now raising and running if a state decides to assume more or less responsibility for an exchange. Are you adaptable? Now, the New York Times reports that the health plan cost for New Yorkers is set to fall. Now, this is great news for consumers, and it's an extraordinary decline in New York's insurance rates for individual consumers. So it shows the profound promise of the Affordable Care Act. But you can't get to the Affordable Care Act if the computer system isn't working. So this is a very clear thing, and I'd like to know more about it. But I'd like you to comment can address. I know that some states have not gotten their exchanges up and running. So how are you adjusting with states that don't have it up and running, and it has great promise for consumers? So how are we making this configuration? And I guess Mr. Cho is the head of the hub. Maybe you should be the one to answer.
Congresswoman, with your permission, could I address the New York issue and the Serco issue? On the New York issue, we were obviously pleased to see that this morning, and I think it reaffirms what competition and transparency can do in a marketplace, and that really is what we're doing in the Affordable Care Act, effective in October and beyond. On the Serco issue, notwithstanding what the Chairman just brought to our attention, Serco is a highly skilled company that has a proven track record in this country and has done a lot of work with other federal agencies. We are actually working with the U.S. corporation, and they are actually present in 3 states, and they were awarded through a full and open competition. So obviously, they do have a track record with security and privacy. And I'll turn it over to Henry to answer the other question.
But also, can this system handle the varying degrees that of astuteness or availability or readiness of different states?
Yes, and that's where I think Henry.
Or do you have a different system for each state, or is it all one central big system? And is it government or private?
The federally facilitated marketplace system is comprised of several actual, kind of working pieces of system architectures that perform eligibility enrollment, QHP and plan management functions, financial management, generating payments for the issuers. The hub, as we mentioned earlier, is a routing tool. It affords the efficiencies that are needed for multiple points that are requesting the same information from authoritative data sources to connect to those data sources and then enforced with a uniform service level. That is a scalable system that is government-owned, and it's privately contracted, but is government-owned. It is.
Who will run it? Will the government run it, or will the private sector run it?
It's a combination of government, staff and contracting staff that will staff an operations center that actually monitors its operations 24 hours a day.
And where is it located?
It's in Columbia, Maryland.
And I would add that one of the advantages of having this hub is that whether states or state-based exchanges or some type of partnership model, or whether they default to the federally facilitated exchange, it's transparent. It's easy for us to make those changes, and that's part of the.
And what is there to protect the privacy of the individual's health records? How do you protect that?
Well, first of all, we don't collect any health record information or store health records. I think that's an interaction between a consumer that ultimately is enrolled in a qualified health plan and in working with that health plan, accessing benefits and utilizing benefits that relationship affords the ability to collect and store and process. That's a relationship between the consumer and the health plan. The ability for us to protect privacy of the individual is working with SSA and IRS and enforcing the very stringent, and rightfully so, 6103 provisions, and flowing that through. Mr. Mulholland and other chief technology officers and chief information officers from around the federal government worked with, as a group, to develop what we call the harmonized privacy and security framework. Even though each agency operates under very strict guidelines, its own guidelines to operationalize FSMA and HIPAA and 6103 in IRS's case, we had to get together because this data via the hub was moving and being requested by multiple entities, including the state endpoints that there are their own marketplaces. So we had to get together and make sure that the implementation of those security and privacy controls and the operations was harmonized and are common across all the agencies and not dissimilar as if we were implementing the program in different parts. So we got together early on to do this to make sure that we have greater security and privacy, kind of enforcement and monitoring, and the bar is set by 6103 and the Privacy Act.
My time has expired. Thank you.
Mr. Desjardins.
Thank you, Mr. Chairman. Ms. Tavenner, I have some questions for you, but first, Mr. Werfel, I just wanted to revisit a bit of the dialogue that you had with Mr. Jordan earlier. He had asked you if Ms. Hall Ingram was in charge of the department that oversaw the targeting of conservative groups, and what was your response to that?
My response is that Ms. Hall Ingram has specific ACA responsibilities, but there are other individuals within IRS who have responsibilities at the same level. But Ms. Hall Ingram does play a coordinating role amongst our various ACA activities.
Okay, and one thing we've had, I guess, a hard time getting anyone from the IRS to say in multiple hearings that we've had is that the IRS was guilty of targeting conservative groups. You stated that you are the most senior accountable member at the IRS currently. Is that correct?
That is correct.
Are you willing to go on record today and tell the American people that the IRS did target conservative groups?
I've testified previously that I believe the use of political labels to screen out applicants for increased scrutiny, inappropriate political labels, is equal to the term targeting. So I don't dispute that.
All right. Well, it's been hard to get someone to say that, and I know that moving forward into this health care law that you have a credibility issue with the American people, and I think it's very important that you be forthright, and I appreciate you saying that today when so many others have taken the fifth. Ms. Tavenner, you had testified earlier about the preparedness of the CMS, and you're feeling pretty comfortable about the ability to be ready on October 1st? Okay. I'd like to submit for the record, without objection, Mr. Chairman, the data collection instrument from the GAO report from June 2013.
Yeah, without objection.
Okay. Ms. Tavenner, we have a document that was obtained that shows that CMS had only completed 20% of its work to establish appropriate privacy protections and the capacity to accept, store, and associate and process documents from individual applicants and enrollees electronically, and the ability to accept image upload associates and paper documentations received from applicants and enrollees. So the fact that ObamaCare became law in March of 2015, but yet as just of a few months ago, the administration had completed only 20% of its work to establish appropriate privacy protections and capacity to accept, store, associate, and process documents from individual applicants, why would you say the administration failed to prioritize privacy protection and data sharing standards?
I can answer that, Congressman.
Well, Ms. Tavenner, first you go ahead, and then I have a question for you, Mr. Cho.
Well, first of all, I would say that GAO reports and other reports are taken at a snapshot in time, and a lot of work has been completed since that time, and I will let Henry speak to the details of that.
Okay. Mr. Cho, are you 100% finished establishing appropriate privacy protections?
No, we are not.
Okay. If not, how much and when will you be?
I think since the last report, we're probably, and this is a very kind of hot ballpark, generalized, roll it up kind of a figure, I would say, with regards to privacy and security, we're probably about 80%.
Okay, so the snapshot a couple months ago, you're at 20, and now you're saying you're at 80. Are you going to be 100% on October 1st?
Yes.
Ms. Tavenner, you feel that that's reasonable, that in 3 years you got to 20%, and now in 75 days we're going to get to 100%?
Yes.
Okay. Also, there's 25% of the work to establish the adequate technology infrastructure and bandwidth to support all the activities with respect to the exchanges. Again, why did the administration fail to prioritize this sooner? I'll ask the same question, Ms. Tavenner.
I don't know that it's a failure to prioritize. There's a certain workflow that has to actually, first you have to put the regulations in process, then you start to develop the product from the regulations, and this is just the work in progress as any complicated project. We're now within the 90-day period of completing the work. Okay,
Mr. Cho, the CMS document given to GAO says that the estimated completion date establishing an adequate technology infrastructure and bandwidth was July 1st, 2013. Did you meet your deadline for completion of this task?
We have, it's a constant changing target, because the target is actually...
So the deadline's moving?
No, the target is October 1st, and we make adjustments as we go to make sure that that target of October 1st is not missed. As of this month, all the infrastructure and the required, hardware, software, capacity, all of that is available and up and running. The specific application software, such as the My Account that I talked about earlier, the enrollment and eligibility pieces, the loading of the QHP information to process an enrollment and a payment to an issuer, that is an ongoing process. All of that code and those databases are still being built throughout the summer.
Okay, so both of you are testifying today that these shortfalls that are in the report that I mentioned are going to be 100% complete on October 1st?
Correct.
Ms. Tavenner?
Yes, sir, and we certainly will have mitigation strategies. I think someone mentioned earlier in our opening comments that we will be prepared. We will start October 1, and we will certainly have hiccups along the way, and we are prepared to deal with those.
Okay, real quickly, when did you learn that the employer mandate would be delayed?
When did I personally? June 24th or June 25th.
Why did the President wait till July 2nd to announce that?
I don't know. It was not part of that discussion, but I actually was made aware that it was being considered on June 24th.
All right. I yield back, Mr. Chairman.
Thank you. The ranking member of the full committee, Mr. Cummings.
Thank you very much, Mr. Chairman. I want to thank you all for being here. I want to thank you for what you do for the American people. Mr. Werfel, I want to pick up on where Chairman Issa was going to take it to a little further. I'd like to ask you about the ongoing investigation into the treatment of Tea Party applicants for tax-exempt status. During our interviews, we have been told by more than one IRS employee that there were progressive or left-leaning groups that received treatment similar to the Tea Party applicants. As part of your internal review, have you identified non-Tea Party groups that received similar treatment?
Yes.
We were told that one category of applicants had their applications denied by the IRS after a 3-year review. Is that right?
Yes, it's my understanding that there is a group or set of groups that had that experience, yes.
As I understand it, last week the IRS was prepared to make a document production to the committee, and by the way, this is a request from the chairman, and those documents would have shown other categories of applicants, categories in addition to the Tea Party groups we have been focusing on to date. Before I go any further, is that right?
Yes.
I understand that our committee does not get access to information about specific taxpayers. I think it's 6103. Is that right? There's certain that prevent us from getting certain information. What Mr. Issa was talking about a little earlier, generally.
That's correct. We'll make certain redactions if we believe that the information would be have too much information so that you could zero in on a specific taxpayer. So we'll make those redactions.
I understand. Under 6103 of Title 26 of the United States Code, the IRS cannot reveal specific taxpayer information. In order to make these determinations, and this is going to what you just said, the IRS have career employees who are experts. This is what they do.
Yes.
In determining what is covered by the statute. Is that correct?
That's correct.
And in this case, these experts determined that the IRS could provide this information to the committee. They said the documents did not reveal specific taxpayers, but instead referred to categories of groups, just like the Tea Party groups. Is that right?
Yes, that's correct.
So based on this established process, we should have received that information last week. And by the way, to his credit, the chairman has been very aggressive in going after documents. But we did not receive that information. Instead, I understand that the Inspector General intervened. Let me say this again. It's my understanding that the Inspector General intervened personally. Now, Mr. Werfel, my question is, can you tell us what he did? Did he call you, and what did he say?
Okay.
In other words, we're being denied, this committee is being denied documents that we have requested. Let me finish. And the chairman, to his credit, has been extremely aggressive in trying to get documents. And I've been accused, by the way, of obstructing the investigation, which is totally ridiculous. I want the documents. Now tell me what the IG said that prevents our committee that our honorable chairman, Mr. Issa, requested. What did he say to you to cause us not to be able to get the documents after your experts told us we should have them? Can you tell us what that's all about?
Yes, we were imminently going to produce a document in an unredacted form that would indicate the identity of a grouping of entities that we felt was similar in kind of scope as Tea Party in terms of its grouping, so that you wouldn't be able to identify a particular taxpayer because the grouping name was so broad. And he reached out when he learned that we were about to produce this information and expressed concern and indicated a disagreement with our internal experts on whether that information was 6103 protected or not. And out of an abundance of caution, the IRS decided to redact that information until we could sort through with the IG his position. And understand why it's different from ours. And we've had subsequent conversations with him where we have reasserted our position that the information should not be redacted, but we have not reached resolution with him at this point.
I don't understand. I thought that the career officials at the IRS, the officials who do this for a living, day after day, hour after hour, already determined that it was okay for the IRS to produce these documents to the committee that Chairman Issa requested. This seems very strange, Mr. Werfel. I know you just started, but has this ever, to your knowledge, happened before? The Inspector General personally intervening to prevent disclosures to the Congress of the United States of America. Have any of your staff members ever heard of this happening before? Now, you're surrounded by folks, you can look around and they may tell you something different. And if they've got some other answers, if they haven't been sworn in, Mr. Chairman, I ask that they be sworn in so we can know of these exceptions. And by the way, Mr. Chairman, I just want the same amount of time that Chairman Issa was given. It was a total of 10 minutes. With unanimous consent, please.
I just don't know the answer to that question. I personally am not aware of any similar situation, but we can take that question back and do a broader inquiry amongst the IRS leadership and other professionals and get an answer.
I ask that you please have that answer to me, if you can, by tomorrow morning. We're going to be seeing the Inspector General tomorrow, and I want to make sure that I do not prejudge him. I do not want to put anything out there to accuse him of anything and then go searching for facts. I simply want the truth so that we can restore the trust. Our interest is in getting as much information as possible. So let me make sure I understand this. If the Inspector General withdraws his objection, will you produce that information to the committee that Chairman Issa requested?
Yes.
Now, let me say something else. Ms. Taverner and Mr. Chow, I heard Mr. Desjardins' questions. And as I sat here and I listened to my good friend, Mr. Desjardins, and he talked about at one point you are at 20% with regard to the privacy protections. And then I think you said, Mr. Chow, correct me if I'm wrong, you're now at about 80%. And then you and Ms. Taverner agreed that by October 1st, you would be at 100%. And if there were any problems or hiccups, in your words, Ms. Taverner, you were prepared for that. Is that correct? Well, I stopped by here for just a moment to thank you for doing what you do to prepare for something that is already the law. Although we're getting ready to vote on it, by the way, for the 38th time, it is the law. And you all have a duty, and I'm so glad that even with all the chatter, you have stayed focused, you have refused to be distracted, and you made sure that the American people, the Affordable Care Act, and the part that you all have to play in that you are prepared to do that. And I want to congratulate you. I know quite often you get negative comments, but the idea that you all took a monumental stance, and I want to say this to your other IRS employees, we appreciate it. Now let me say one last thing in my last 1 minute. I've said it from this dais before, and I will say it until I die. This is the United States of America. Every single person on this dais, if they have ever hired anybody and ran anything, has fired somebody. And just because we have some bad apples that don't do the right things does not mean that we stop operating. It means that we take the bad apples out and we continue forward. This whole idea that there was a problem in the IRS and there are ongoing problems and the problems that you're trying to straighten out, Mr. Werfel, to your credit, we should not then suddenly wave a white flag. Say, oh, we can't carry out the Affordable Care Act. This is America. We're better than that. And I know that you know that. And I get tired of people just because there are problems, suddenly they said, oh, no, we can't carry out the law. No, we are better than that. And so I want to thank you all, and may God bless.
Two quick notes here. Mr. Werfel, I know you have a hearing at 1 o'clock today. We've been at this for a little over 2 hours at this point. I know you need to be excused pretty quickly. You have time for one more question, or do you need to go ahead and scoot out now?
No, absolutely. Please.
Okay. It is Mr. Woodall is up.
Thank you, Mr. Chairman, and thank you, Mr. Werfel, for spending a little more time with us. I actually had a couple of questions for you because I think you're a very serious public servant. I've been a public servant in a couple of different capacities myself, and I think it's fine for us to disagree about the issues. I think we have to be serious about the work, and I appreciate Mr. Cummings' comments about you had a responsibility, Ms. Taverner. You had a legal responsibility, and you carried it out, and he's tired of hearing excuses for why it is we can't get things done. My question to you, Mr. Werfel, is That's what we saw on the Treasury blog. We just can't get things done. Ms. Tavener says we were only at 20% a month ago, but we're going to make it happen by October 1st. The President seems to have decided, or the Secretary seems to have decided, that no, we just can't get things done. No doubt to the frustration of my friend from Maryland. We've got a bill on the floor this week that makes that statutory change, taking the administration at its word that they can't get it done. We make that statutory change from 2014 to 2015. Several times during this hearing, folks have said, we just have to follow the law. In your discussion with the chairman about 6103, you said, there may be some policy discussions about 6103 that we ought to have, but we at the IRS, we just follow the law. Mr. Cummings applauding CMS for following the law, doing what was required by law. Why is it that we don't have Treasury's support for making a statutory change to the law rather than just doing things that we would like to do administratively? I think one of the real challenges we have is we don't have any need to work together any longer. We want to do something, we just do it here on Capitol Hill. You guys, the administration, decide, you don't like the way things are going, you just do something different. Why is it that it would not be better for the public servants who have to implement these laws for us to actually change the law rather than do it through blog posts and administrative decisions?
The challenge that I have, Congressman, and I appreciate the question, is that the role that the IRS has in relationship to Treasury is they make determinations on policy, they work on whether we're going to support or oppose, and how we're going to work with Congress on the laws itself, and we really are all about administration. So from my vantage point, I can answer questions for you on the decision that the Treasury made and how it impacts the IRS's ability to implement the ACA, but in terms of whether it should be legislatively incorporated is something I'd have to defer to Treasury.
I understand your challenges in that respect. And I think about what Mr. Cummings said about applauding the good work of IRS employees across the country and a few bad apples. I mean, I say regularly at town hall meetings, you all have a horrendous job, and the job that you have that is made so horrendous is made so horrendous by the laws that we pass here on Capitol Hill. I feel a great burden for the responsibility that we put on you. I guess what I'm asking is, we just perpetuate the frustration with IRS employees when we put them in untenable positions. And putting the IRS in the untenable position of having statutes that require laws to be enforced and saying, but no, we're not going to enforce those laws, simply perpetuates the negative stereotypes that go on out there today. So understanding that you might not be able to speculate on why those decisions were made at Treasury, wouldn't you push up the ladder? Hey, here's the Congress that wants to work with us to get this done in a statutory way for the House, the Senate, the President to come together and do exactly what Treasury seems to be asking for. Why can't we come together and do that? Why won't you push that message up the chain?
Well, without particularly commenting on this issue, I think in general what the IRS does is we do have a guiding principle that the simpler the tax code, the simpler the laws are, the more clear they are, the more we're going to be able to administer them effectively and efficiently. And so, we have that guiding principle, and then as we deal with different legal issues that arise, Treasury will consult with us on the administrative aspects of them.
Well, but I understand that, and I absolutely agree with that. I would say shall begin after December 31st, 2013 is pretty simple. I would say that subsidies shall apply to state-based exchanges is pretty simple. I mean, we've done the best we can in terms of simple law, and folks have gone and reinterpreted what was very simple law. And that's the frustration to me as a legislator. I hear what you say to the chairman. 6103 is clear. It's black-letter law, Mr. Chairman. We can't avoid it. And I'm thinking, for Pete's sakes, you've decided that you don't like the mandate timing, so you'll do something different there. You decide you don't like the subsidy implementation, so you'll do something different there. These are very serious men, the chairman and the ranking member. You could just decide, you know what, 6103, it says Finance Committee and Ways and Means Chairman, but it probably should have included the Oversight guys too. Probably should have. The subsidies probably should have done the federal exchanges. The deadline probably should have been a year out, but you don't. There's a lot of lack of confidence in America, in both the administration and the Congress these days. We have opportunities to work together instead of working against each other. And it frustrates me that even on something as simple as a date change, we can't even take advantage of that opportunity to restore faith in the people's government here in Washington. And I thank you all for being here. Thank you, Mr. Chairman.
Thank you. Mr. Werfel, I know you've got to scoot out to get ready for the next hearing. Thank you for being here. Mr. Milholland, will you be able to remain, or?
I can remain.
That'd be great if you can, so we can continue to answer for IRS. Mr. Perry.
Thank you, Mr. Chairman. Ladies and gentlemen, thank you very much for being here. We understand on this committee that, and in Congress, that you have a duty to perform, and you don't always necessarily agree with what we send out of this place, but you do your duty and you perform it as best you can. We appreciate that. We also have a duty as well, and I would take some exception with the statement that our duty is to make sure this works. We have a duty to our constituents to make sure that we echo their concerns and ask questions on their behalf. And on my part, a lot of my constituents are concerned and skeptical about this law and the contents therein. And so I want to ask some questions on their behalf. I guess, Mr. Cho, I'll start with you because I'm not really sure who else to start with. Is there one person who's in charge, or who will be in charge of the data hub?
In CMS, we typically have a combination of lead policy, or what we call business owners of the hub. The administrator ultimately is accountable and responsible for any of the technology that we implement to support the programs, but the day-to-day operation is governed by a board of business and technical leadership in the agency. That makes
In CMS or the IRS?
There is a CMS and as well as a cross-agency.
So it's a bunch of people will never have, in my opinion, and I think in a lot of American people's opinion, because of that, there's never really going to be true accountability, because something happens, everybody's going to point to everybody else. I mean, how many people are we talking about? Do you know? I mean, you're in charge of some of this stuff. Do you know?
I think when it boils down to it, there's only less than a dozen people who are truly...
Less than a dozen. Okay, and some from... There are 5 agencies. Somebody from the 5 agencies, a person from each of the 5 agencies that are getting data in, taking data out? I mean...
Correct.
Okay, so, I mean, you're going to notice my Social Security number, my email address, my home address, my financial information, whether I ever got a DUI. You're going to know this portion of government, the federal government's going to know literally everything about me, and everything about every 300+ million Americans that they find personal and are concerned about having their neighbors know about. And so they're right, I think, to be concerned. Who determines what questions are asked? And I know you kind of alluded to, at least in one part, that you're not going to have personal information or personally identifiable information, but in another sense, I thought you said that you're going to know the home address, the email address, ethnicity. Who determines the question? Why is ethnicity important? Why is whether my wife is pregnant important? And when does she have to report it, or when do you find out? And what do you do with that?
We make the proposal under the Paperwork Reduction Act, in which actually the public and Congress and anyone or the public at large can comment on the questions that we've asked, that we've included, that we felt essential to be part of that streamlined application that's online to apply for affordable care.
So you make a recommendation, and we can provide comment. And what happens with our comments when we object?
I think similar to rulemaking, we factor those comments in and categorize them and take a serious look at the policy and legal angles and the technical implementation angles of it, and we try to accommodate the kind of the very, very huge concerns that we get back under.
So you're with CMS. Why is ethnicity important? Who's it important to?
I am on the IT side. I cannot answer.
Yeah, but that's the thing. You're in charge. You're one of these guys that are at the top. Are you one of the less than a dozen people on the committee in charge of the data hub? Are you one of those people?
Yes.
Okay, so if you don't know this, who does? Who knows the answer? And shouldn't you know it?
I think within my purview, I don't try to question every detailed policy that I am asked to implement. I am more concerned about capturing the requirements to make sure the systems reflect.
But you're one of the people that weighs in on whether it's important or not for your organization and what you do. And this is the American people's personal information. So it needs to be important to somebody. If everybody took your opinion, Nothing's important to anybody as long as the next guy said it was. I mean, the fact that you didn't know about this Serco, I mean, do you think the American people believe or know right now that all this information about them is going to be handed off in some form to private contractors? Do you think they know that?
I think they will know because they are in charge of consenting to that release.
So on the release, it's going to say, I'm giving my information to CMS or I'm giving my information to Serco?
It's actually the process. So if you're in that inconsistency period, you are giving consent that we will be handling any issues that you have.
You'll be handling it, but it doesn't say that your information will be handled through us via contract by a private organization who's owned by a British company or by MasterCard or whoever the contractor happens to be at that time.
Let me try to help answer some of these questions, because I think the accountability obviously stops with the CMS administrator, and that's me. And then we do have business owners, and Henry is responsible for the IT implementation. Let me start with your question about health information and a reminder that the hub does not store any information, but it does not even ask for health information. The only time that pregnancy becomes an issue is obviously if someone is qualifying for Medicaid and there are benefits, they're eligible for Medicaid and maybe they're pregnant. So it varies state by state. So that would be the reason for the pregnancy question. Much of the information that we ask is required by law. And if you remember, a couple of months ago, we went from a long application process down to what we're calling a 3-page application for an individual who's applying on the marketplace. But once you start to get inside, whether it's Medicaid or CHIP, there may be additional questions that we need to answer in order to help someone get eligibility. That's usually done at the state level. There is no health information. When we work with Serco, Serco is helping with enrollment and eligibility. So there is data that we store around things such as your email address, such as your phone number, such as Social Security. But part of that is stored so that if you have a dispute about whether or not you were eligible or you have an appeal, we have that information. But it's not kept on the hub.
It's stored somewhere. And Mr. Chairman, with indulgence, one last question is for Mr. Milholland. We heard earlier that there would be penalties for folks that had breached the confidence of the American people by providing that information to folks outside, tax information, so on and so forth. You're with the IRS. Let me ask you this. Regarding the information regarding targeting political organizations that we recently learned about, has anybody been penalized at this point that you know of in your organization?
The only thing I'm aware of is people no longer in the jobs they were in.
Have they lost their pay?
That don't know.
Thank you, Mr. Chairman. Yield back.
Thank you. Mr. McHenry.
Thank you, Mr. Chairman. Mr. Duncan, in your March report of this year, TIGTA gave no indication there would be problems with the IRS's implementation of reporting requirements. Is that correct?
That's correct.
Okay. So does that include Section 6055 that requires insurers to report about the coverage that they provide?
There are several information requirements from insurers, employers, from the exchange itself on a monthly and annual basis. So all of that information will flow to the Internal Revenue Service and has to be processed, maintained, and kept.
But you had no issues with that?
That is still not really done until 2014 will that data start to flow to the IRS.
Okay, but does this include Section 6056 that requires employers to provide information on the health insurance they provide? So
we're very concerned about that with the recent change and the recent
No, but prior to that, we're talking about your March report. I mean, because you're there to make sure that the IRS is moving along in the path here.
That's correct.
Right. And so in your March report, you said they didn't have any issues with this process of getting that information, right?
That was the information that they were collecting for the income and family size verification and the premium tax, and the overall plan that they had in place looked good.
Looked good, okay. So, when we see the President announce this change, right, on the employer mandate, And then we see this other movement in terms of reporting requirements, right? Which you have the business mandate, then the reporting requirements, the President, and through this administrative procedure here, they've said, well, we're just not really going to verify very much, right? But is there in basis in practice, right, saying that they really don't have that capacity? I mean, according to TIGTA.
Yeah, in accordance with what we reviewed and the application that we looked at the IRS, and our understanding as of today is the IRS will continue to provide to the exchanges through the HHS hub the income and family size information. Now, we did not see in our review that there was a major change in the IRS need or requirement to provide that information if it's available.
Yeah, but I mean, this is the verification process to ensure that people are complying with it, right?
Yeah, I just want to make sure, though, that we understand that the IRS information is only one set of information that the exchange will use in looking at and determining what the final income and family size data should be.
So let's run a scenario here, okay? So, you know, in a state that doesn't expand Medicaid, for instance, North Carolina being one, and I represent a district in North Carolina, a man who earns $15,000, we're just going to walk through this scenario so people have an idea, would be eligible for a $3,400 subsidy if his employer does not extend an offer of affordable coverage to him or her, for instance. And so in 2014, with the federal government, would they be able to verify whether this individual had an offer of affordable coverage at work?
I assume the HHS or the exchange at the state level would be in a position.
We don't have an exchange at the state level.
Then the federal exchange would have to be doing that. And they would ask for information from the Internal Revenue Service as well as other locations.
Okay. So if, to Ms. Tavener, if an individual fails to report that he has an offer of affordable employer-sponsored insurance, right, will he receive a subsidy of that $3,400?
When an individual does do the self-attestation, they would verify whether or not they had employer-sponsored insurance.
Right. So they're going to say, hey, here's the deal. Didn't get it. Give me $3,400 subsidy. So you know, if I'm verifying for myself, right?
If you're verifying for yourself and you say that it's available and you didn't get it, you would not be eligible for the tax credit. And a reminder.
Right, but who's going to say I'm not eligible for free stuff?
So I'll remind you that you sign, when you complete the application, that this is under law, perjury, okay? So there are consequences to an individual who's not truthful on their application.
So what kind of enforcement are you going to have on that truthfulness?
Obviously, we would follow law.
Right, but you have to have people to execute the following of the law. Are you going to ring them up and say, hey, by the way, were you honest on this self-attestation?
Well, we will look at ways to verify.
Well, you'll look at it. Okay, we're talking about this going into effect this fall. We want something a little more than a look for. What is your process to verify that what they said was in fact true?
So there are a couple of ways. Obviously, we will verify first with the IRS, with SSA information that's available. If we're not able to get everything we need there, we will work with private commercial products, such as Equifax. So
Equifax would have knowledge on whether an employee of my brother's business was offered a health insurance plan that was commensurate with the requirement under federal law. Equifax would have that knowledge?
We are looking at a process, and I'll be happy to get back to you with those details. So I need to walk you through the process, and I'm happy.
But I would think you would sort of think this through with this big announcement that we're going to waive the employer mandate.
We are thinking
it through. But you leave the individual mandate. So people are required under compulsion of law, right, which apparently you haven't thought about the enforcement of that law, which is sort of interesting, and maybe sort of liberating for some people, by the way. That you still have it on the law, but you don't have any enforcement mechanism.
and I'm happy to get back with you with that process.
Well, I would hope you would get back with us, and I hope you would think more deeply about this when you testify to Congress about something this important, that you would have taken a little bit of time to think through that verification process and that enforcement mechanism that you have enormous authority, as well as the IRS, to enforce it. And so with that, Mr. Chairman, thank you for the indulgence of time, and I didn't get to the fullness of the questions I had, but this is outrageous, the non-answer that I was given, and I appreciate the Chairman's work on this.
Ms. Tammer, about how much time do you think, to be able to come back on his question?
Yes, just a few days.
A few days, great. Thank you for that. Mrs. Black.
Thank you, Mr. Chairman. I want to thank you and the committee members for allowing me to sit on the committee and be able to ask questions to this very important issue. I want to thank all of you for being here to testify as well. This is something that is really very near and dear to my heart because I come from a state called Tennessee where we had TennCare. We had the pilot project. So I'm very familiar with a lot of what's going on. It has been reported by one of the members of this committee. There has been a lot of information out there that I have put out to say there are questions that need to be answered. And I'm glad that you're here today to answer those. I do want to go back to say that it is very concerning that there's a conflict. There's a conflict between what you say and what we read. And I want to start with the first of those because I want to go back to a system of records notice. And it says, and I quote, "Records are maintained with identifiers for all transactions for a period of 10 years after they are entered into the system. Records are housed in both active and archival files in accordance with the CMS data and document management policies and standards." It has been said over and over and over again by you, Ms. Tavenner, that these records are not kept. How is it that we see in the systems of records notice this is what we're being told, and yet you say, and this is why there is a lack of confidence in the people of this country, is that we don't have confidence that what we hear and what is actually there matches up. Ms. Tavenner, can you address that?
Yes, Congresswoman, I can. I have said that we do not store information in the hub. I have also said, and it is obvious by what we supplied in our systems of record notice, that we do store information on the marketplace, which is separate from the hub.
So let's be very, very clear that this information is being stored. When we continue to say, oh, this information is not stored, I think that people then go, oh, you're wrong in saying it's stored. It is stored, and we have documentation. Now, let me go to the second piece.
Well, as I said in my opening testimony, there are two systems, and it's important to understand that. One is the hub, which is a router, and the other is actually...
Which is a router that has a lot of people inputting information and taking out information. So I'm still not confident that what's been said here today, that all of this is protected, because I have additional questions, which I know I won't have time to get to, about what are the background checks, who will have that access. But let me also go to the next question on this, because it was referenced that there is no personal health information that is collected, and I want to go to a documentation that was put out, I guess, about 2 weeks ago. And this is, I'm going to the section of verification of eligibility for minimum essential coverage other than through an eligible employer-sponsored program. And I am in the section, and I will give you the number of that section, 155.320. So here's what it says, and I'm reading out of the fourth paragraph in here that says, finally, we propose an added paragraph to provide consistent with 45 CFR, and there's a lot of other, I won't go through that. And this is a quote, "A health plan that is a government program providing public benefits is expressly authorized to disclose personal health information as that term is defined in 45 CFR 160.103 that relates to eligibility for or enrollment in the health plan to HHS for verification of applicants' eligibility for minimum essential coverage as a part of the eligibility determination process for advance payments for premium tax credits." It specifically says in here that they are expressly authorized to disclose private health information. Can you speak to this?
I can answer this. Something like a birth date that exists in one particular context can be treated very differently and called and wrapped around, for example, personal health information when it appears in another context, such as your health record. I think the minimum essential coverage, the intent is to check other sources of potential coverage to determine whether if that coverage would be duplicative, supplemental, or contradictory to what the law has indicated, that you cannot be in an exchange or a marketplace benefit receiving a premium tax credit and enrolled in something else that's also a government program. So that information, when we check that, if you look at it in the context of how it's delivered to us, for example, from VA, it is part of a health record, but it is just the date of eligibility. We don't pull any, it's a vernacular, kind of vocabulary, contextual kind of issue. So it's not clinically related. It is just a check on the status of your eligibility.
Well, I hear what you're saying there, but this specifically says is expressly authorized to disclose personal health information.
Right, but I think
I'm going to need to get, and we can have another conversation here, but I'm going to need to get assurances that when you have an expressed authorization to disclose personal health information, that we give assurances to our constituents, my constituents, that this information is not going to be shared with people that shouldn't be getting it. And I don't still have assurances in what I'm seeing here. I think, Mr. Chairman, there needs to be many more of these hearings, to both for those congressmen that are concerned about this, as well as, more importantly, my constituents and the public who are really concerned about what has happened, most recently with the IRS, and how information has not been protected and people have been targeted. And likewise, I think there are many more questions about navigators and what kinds of background checks they have, what kind of training they have. This is something that certainly needs to be talked about a whole lot more. And again, I yield back. I know my time is up. Mr. Chairman, once again, thank you for allowing me to be here at this committee hearing.
Okay, I thank the lady, and I thank the panel. I know we've gone through a lot of questioning. There's just a few of us have some follow-up questioning, and if you will indulge me on that. And I want to echo the point that was just made by the gentlelady from Tennessee. I mean, this is not only the idea that it's within the regulations that you've published yourself, but the concept that there are certainly circumstances where a lot of that can be done without the consent of the individual whose records they are. I mean, and I know it goes to contractors. And nobody knows who those contractors are at this point in time. And we are 75 days away from implementation, and you can't identify with specificity who it is, who are some of the contractors, and what kind of things have been done. But to assure the credibility of their participation in the system. But you talked about harmonizing, Mr. Chow and others, the work that's going to be done among the various agencies in this database. And therefore, you're going to pull in the activity. And I know the IRS has a system which has been effective, or at least the more effective. But I look at the agency scorecards, and I'm talking about harmonization. And this is the agency, federal departments and agencies' cross-priority goals in cybersecurity for the second quarter of 2013. So this is the most recent one. And when we begin to talk about those who are on the scorecard, two of the poorest performers are HHS and the Social Security Administration, both performing under the requirement that the executive branch will achieve 95% implementation of the cybersecurity capabilities. So who's going to be, are we going to rise to the level of the IRS, or is it going to be down to the lowest common denominator with respect to the HHS and Social Security Information Association?
I think working with IRS, certainly, I mentioned earlier that they've set the bar for security and privacy of protected, information, specifically in their case under 6103. And based upon our experience, working with systems that process personally identifiable information relative to eligibility, particularly like Medicare eligibility or enrollment dates and history of enrollments. I can't speak to the HHS level. There are 11 operating divisions or agencies within HHS, of which CMS is just one of the 11. So I don't know if that scorecard reflects, the individual CMS progress, but we can certainly look into that and get back to you.
Well, two of the three components that are going to be critical among these are the worst performers. But less so than part of this is this is a dynamic network. And people keep talking about the fact, well, information isn't going to be connected here or stored in one particular place. But it's just once one has access into this system, particularly in light now of the fact that it's going to have so many different places in which responsibility for security will be contained, including, as best as I can understand, the fact that there are at least 15 states who will be operating their own exchanges. And Mr. Duncan, maybe you can speak to some of this. But is plan management, Mr. Duncan, does plan management include security?
I don't think Mr. Duncan can speak to that.
Mr. Chow, well, let me ask him his question. He's an Inspector General. Does plan management include security?
Plan management should be considered when you build any application. It should be baked into the application, for sure.
Mr. Chow, are you saying plan management does not include security?
No, I'm saying it does include security, and plan management is a core function inside the federally facilitated
Okay, well, here I have, and this is the report of the GAO that was done, recently established, and it says, for those 15 FEEs which states will assist with plan management functions, CMS will rely on the states to ensure the exchanges are ready by October 2013. So all of this work you're talking about, the fact of the matter is there's 15 different states. And you're basically saying, Ms. Tavenner, well, we're going to rely on them. They're going to sign documents that say that they're okay, but we're going to rely on them. This is your document. Is that accurate? Ms. Tavenner?
I'm trying to answer. Actually, it's a little more interactive than that. We have oversight. Even when what we do is we allow state-based exchanges to build their own platform, but we also work closely with them both on security plans, on plan management.
And how closely have you worked? Let me go down into the footnote. Footnote 42. 7 of the 15 states submitted an application and were approved to assist in other plan management functions. Additional 7 states were not required to submit an application, and CMS officials indicated the agency has no formal monitoring relationship with the states. Instead, CMS conducted a one-day review of these states. So here we have the greatest data hub that's ever been put together with private information in the history of the government. It is going to be related back to your reliance on the states to do it. You say you have oversight, and by the GAO's report, what was done with 7 of those states was you went and you spent one day on the review, presumably looking at a whole variety of issues, not just security.
In this case, those 7 states that you're talking about, I don't have the benefit of your document, but in front of me.
This is the GAO report. Mr. Dickin, you made the report.
Yes, I've read the report, but I'm just saying I don't have that page in front of me. But the 7 states that you're referring to are actually interested in doing plan management, which is the work with the issuers, which is a function they do today through their state insurance commission. And so we do work closely with the insurance.
Well, what do you do to assure the security of the system with them? Because it seems to me that you are...
So the security of the system goes back to the hub and accessing the hub, which is part of our plan. So just because they do plan management inside a state, they do not have a separate mechanism to enter the hub. They enter the hub the same way we've talked about applies to all 50 states. The two are not the same.
To add to that, we also conduct technical reviews, which include security components, and we sign the essential security documentation that's needed and agreements, such as computer matching agreements and data use agreements with all the states. So there are other checks and balances that are in place, as I mentioned earlier, the overall security framework.
What assurances do we have that the states are capable to protect the system, at least at their entrance point, and that your system is capable of protecting itself against the high level of effectively cyber attacks that are taking down the most sophisticated systems in the world?
I think with ingress points and connection points with the federally operated IT and managed IT, I think we definitely apply, as you well know, under Homeland Security and at the department level and even at the agency level, lots of continuous monitoring of the networks and intrusion. I think that
it's saying the report that I just have that came out from the colleges is
No,
that they can be months before anybody realizes that they're even in there.
And I'm saying that with regard to the ability to impose the same federal requirements on state systems and networks, I don't think we have applicable law that clears our ability to impose that on states, other than asking them to sign agreements.
All right, my time has expired, and I need to respect the time. So I'll turn it over to the gentlelady from California, Ms. Spear.
Mr. Chairman, thank you. You know, when Medicare was first passed as a law, there were huge cries by many in Congress about how it was going to be horrific and bring socialism into this country. Fast forward to when we were debating the Affordable Care Act, and signs across this country and at town halls that I was party to were signs that said, "Don't touch my Medicare." I believe there will be a time when the signs will be, "Don't touch my ACA benefits." I am really apologizing to each of you for what I think has been a counterproductive engagement today. I think most of what has happened has been efforts to throw sand into the gears, and I don't think that's what this committee is supposed to do. We're supposed to drill down to find out whether or not there are any oversights, and if there are, help you fix those oversights. I have a lot of confidence in what you're doing. It is not going to be perfect out of the chute. It just isn't. And I think we do great harm when we continue to spew out lies, much like the lies about the death panels. For those that have an agenda to dismantle the Affordable Care Act, this is not where they need to be. For those that want to make sure it works successfully, this is where they should be. And I want to thank each and every one of you for your efforts to try and make this a successful one. Now, I would like to ask one question. As you have weighed in, as you have dived deeply into this implementation, is there a particular area that you have some concerns about that we haven't addressed that we should address, either by legislation or by information that we convey to our constituents?
I thank you for your support. And I would say that our biggest concern is that we have adequate resources to do the work. The President's budget has proposed resources for 2014. It is important, if you want, and we want, to take privacy and security seriously, we need to have the resources to be able to do that. And so I would appreciate your support in that area, and I thank you for your earlier comments. We have a great team at CMS, and we're working very hard, and we look forward to October 1st.
Anyone else? Yes, Mr. Milholland.
As Mr. Werfel also commented about the budget issues, our primary concern is resources also. So I would echo Mrs. Taverner's comments.
Mr. Duncan?
Yes. The Inspector General has three basic concerns, and I think I mentioned those in my initial testimony, but I'll recap them. The protection of federal tax data at exchanges, we believe, is a very specific requirement. The Safeguards program at the IRS, we are currently doing an audit of that program as we speak, and we think they're going to need the resources and funding to expand significantly to cover the additional state exchanges. And it's very specific requirements, as has been talked about before, for that. Also, the fraud prevention systems, that they're ready by January of 15. That's the Return Review Program at the IRS, which brings analytics and stops the refund from going out the door. not after the fact, and try to recoup it after the money is sent out. And also the thing we've been talking about quite often, which is the interagency testing. This is all the components, including the IRS, that there is sufficient testing for the entire system, not just the pieces. Those would be my 3 concerns.
All right. Thank you. Anyone else?
I can just note that from our GAO report, I think we highlight kind of 2 key areas that are remaining that are key for the October 1st implementation. We've certainly talked a lot today about the data hub as a key tool for that. We've talked now some about plan management as a separate core function. The last core function that we spoke to was consumer assistance. That's an area where much of that is happening before October 1st, and certainly another core area where there have been some delays and important activities that need to take place by October 1st.
All right, Mr. Chairman, let me just end by sharing 3 quotations about how people were so exercised about Medicare when it was being contemplated. Ronald Reagan in 1961 said, "If you don't stop Medicare, one of these days you and I are going to spend our sunset years telling our children and our children's children what it once was like in America when men were free." George H.W. Bush in 1964 described Medicare as socialized medicine. Barry Goldwater said in 1964, "Having given our pensioners their medical care in kind, why not food baskets? Why not public housing accommodations? Why not vacation resorts? Why not a ration of cigarettes for those who smoke and beer for those who drink?" We really have got to get beyond the rhetoric.
Will the gentlelady yield for a question?
I'm just closing.
Okay.
You can certainly carry on in your recount, but I would just say rhetoric is not what we need to be talking about today. What we need to be talking about is the sum and substance of how we make this operate effectively, efficiently, with privacy concerns resolved, with security concerns resolved, and with the understanding that the fraud that may occur, if it is fraud, or just a assessment of what one's salary is that at the end it is going to be figured out and payments will be made back to the U.S. Treasury for the fraud that may have occurred when someone said they were making less when they were really making more. Now, any other fraud that occurs, it may be a subject that we would have to discuss further. But at this point, Mr. Chairman, I thank you for chairing this hearing. And we have had a great relationship, and I look forward to more of the same.
Thank you. Let me ask a couple questions. We're getting close. So I know you all been at this a very long time. The verification that they qualify for a subsidy, is that done at the exchange level or at CMS? Who verifies that they qualify?
The verification services are processed by CMS systems for federally facilitated marketplaces and via the hub connecting to the income verification sources.
Okay.
For state-based marketplaces, they do that themselves, connected to the hub to the income sources.
So with that, they've got to have access to all of that raw data to be able to make the decision. They're not just getting yes, no answers. When they pull data, they're pulling data. So it's entering fields.
Yes, but it's also, I don't want folks to think that it's a whole array of tax return information or health.
Can we get a list?
Narrow.
Can we get a list as it stands at this point right now? What information is coming down? Because I assume it's on their 1040 line 47, such and such. This data is made available. Trying to find out what is made available to an individual, and that because if the exchange makes the decision, that means they've got to have access to the raw data.
We can get you information. And
Be terrific. And just on the broad range, I'm sure it's all been laid out at this point, obviously, to know what all that involves on it. As walked down, and this came up earlier, Mr. Tavener, about the delay in the employer mandate. You had mentioned late June, June 24th, that you had received notification that was going to be delayed.
Let me be clear, June 24th or June 25th? I'm
That's
not
fine.
sure which
Yeah,
day.
that's fine. Yeah, I wouldn't hold you accountable to that one way or the other. But the question is, this has to be an ongoing part of the conversation. This was not a sudden decision late in June that the administration thought this is a bad idea, let's delay it. There were a lot of factors that went into it. Was the creation of this data hub and some of the connections between the employers submitting information about their insurance and what insurance that they're providing to employees and the complicated nature of that, was that a part of this conversation? Did CMS or IRS have conversations with the administration to say, we've got all of this together, this is coming together well, we don't know yet how we're going to get employers to tell us their information on the employees?
Mr. Chairman, I cannot speak for IRS, but we did not have conversation.
So the first you'd heard about this at all, or people at CMS had heard about this at all, was June 24th or 25th?
The first I heard of it.
Okay. With the IRS side, where are you? Because at some point it sounds like there'll be employers will have to submit, my employee has been offered this coverage. Is that system in place? Is IRS prepared to be able to do that yet?
That particular deliverable is 2015. This direction to move it to the right slides that, I think it was roughly about 6 months, if I recall correctly. But in any case, the IRS has to be prepared on day one with respect to those employers who choose to voluntarily provide the information. So the fact that Treasury moved the requirement to the right doesn't for...
No, my question is, was there dialogue between IRS, administration, Treasury, whoever it may be, to be able to voice, we don't have a mechanism to yet be able to verify this with the employers? So was that a part of the conversation? Has there been a notification back? Because that, as you said, it's voluntary at this point. That has all been moved a year back. What was the dialogue in advance?
I was not privy to that conversation.
Okay. Is there a mechanism in place? Was there a plan to have a mechanism in place for 2014 for employers to be able to verify their employees do have qualified health plans?
The mechanism that was to be in place was that they would report to the IRS.
Right.
And, I mean, that was part of the requirements.
Is that mechanism in place now?
No, it's not.
Okay. When did that get pulled? Because I'm sure that didn't get pulled June the 24th or 25th, as far as that requiring that field to be turned in.
But it's part of the release that will come later, 2015. I mean, it's not in the system as of October 1, which we're doing this year.
Right. I understand the date's been moved on it. Prior to the 3rd of July, when it was announced that's going to be delayed, was this planned to be a part of the IRS reporting system that employers would report starting in this year?
It was part of our plan, but not to be implemented this year.
So regardless, employers weren't going to report either way?
That's correct, this year.
Okay. So the delay that's occurred to say we're not going to require that of employers this year already lines up with what was happening data anyway, or there was a change in the plan to gather data this year? That's what I'm trying to determine.
I'm not sure I fully understand your question. I'll just say again that the implementation of that employer reporting wouldn't happen until 2015.
And that was the plan from the beginning?
From the beginning, yes, sir.
Okay. That's all I'm trying to be able to determine from there. Ms. Taverner, you mentioned earlier that there are third-party sources of financial information. You mentioned even Equifax or some other outside organization. What's the connection there on the database with third-party organizations?
We're looking, because there was talk of the requirement to have, kind of employer offer of coverage. We tried to look at our current contractor capabilities to see if there is some commercially available way to do that. And it's just in conversation and discussion right now, absent of, when things were known or not known. It was just, for me, it was understanding the requirement and seeing if there's a data source that's available.
And is that a hub-type relationship to be able to pull data when it's needed, or is it a matter of getting data from them to be able to put onto the other piece? Because we've talked about two different functions here.
Yes, it would be connected to the hub to pull that data from.
There's a tremendous amount of credit information out there that's an error, obviously. What I'm trying to determine is now we're fighting off 3 different agencies that have credit information trying to get things fixed. We would now have to also add CMS into that mix as well, that if there's an error in my system, how would people know what is there and whether they've been accepted or denied, and how would they get that fixed?
Chairman, I believe that when the, saying Equifax and credit report is almost synonymous these days, when we work with a company, Equifax, they have lots of data sources that they make available.
Right.
I think the employer offer of coverage, that potential for having that data, is part of their overall working with employers to pull payroll information to help service benefit administration, kind of practices for large employers, for the employees. I don't think it falls under the FCRA kind of realm.
Right, but the thought on it is well, there's a whole bunch of issues. Just false information at all is hard enough to be able to track on it. But the thought is here, if they work for this certain employer, then they have been offered care. Is the assumption there, or is Equifax assuming that they'll be somehow reported, there's an employee that works for me, this one was offered, this one wasn't? It's just a matter of their payroll data, so they're paid by this company has a qualified health plan, so they must have been offered. Is that just the assumption?
Based on conversations with Equifax, they are having conversations with their employer clients that have this data relationship, and they're seeing if that's something that the employer community wants to provide as a service or a benefit to their employees so that they don't have to constantly answer questions and queries about coming back to them about offer of coverage.
Okay, one last question then, Mr. Jordan. I think that's some wrap up, and we need to get you all out of here, obviously. The individuals within the exchanges, and we've got an authorized user that's been authenticated, they've signed in, we know who they are, yes, they're one of ours. In a state, they're viewing data, trying to make a decision. Let's say this is something that's not automated. I assume most of the decisions are going to be made with parameters and it's going to be automated. Is that your assumption as well?
We are certainly going to encourage automation.
Yeah, I would assume the vast majority. You have millions of people coming through, especially initially. Those decisions aren't going to be made on someone's desk with a big stack.
But it will no doubt be a combination of manual and automation.
Okay, so that individual that's there within a state that's making a decision on it has access to all that information. The challenge becomes, do we have a system in place for background checks for those individuals, limiting those individuals? If we visit with NSA, they can tell us exactly how many people have access to that information, and every time that information is accessed, there's an accountability process with it. What I'm trying to determine is there are occasionally authorized users that do have access to it, but they use it in an unauthorized way, if that makes sense.
So and I think the question you're asking is who would help someone with an application?
No, not necessarily. No, it's an individual that has access to the information. They're authenticated as a person that is an employee there, whether it be a private contractor that works for a state or a state employee that's been authorized to be a part of the exchange. They have access to that information. What boundaries are there that they don't use that information for unauthorized purposes?
From a program management perspective, when I talked about the harmonized security and privacy framework, and I did mention that there are some things we cannot necessarily enforce upon states, but we can sign agreements with them. And in signing these agreements, they abide by certain security controls and thresholds that they in essence, promise to uphold as part of the security practices. Now, in the world of security and cybersecurity and awareness today and security policies and imposing this operationally, if you look at the multiple security frameworks that are available, federal government, state government, and commercial, there's a significant overlap in that we adopt the same controls, such as access management, authentication to a certain degree of assurance, in authorizing their entrance into the systems. So we're in agreement on a very vast majority, large vast majority of controls that are applied.
Right. I'm talking about just the background of how do we show that this person, once they've accessed data, that data that they access is for official purposes, not unofficial purposes. Because you now have data that was was in a closed system that's opening up a little bit to new people or then accessing information. So am I making sense on that?
Yes. Well,
again, it's an authenticated user. It's just not using for authorized purposes.
I think we have other security monitoring tools to look at behaviors and trends in how people are using the system. And
all right, we'll follow up on that in the days to come. The SPR that we talked about, Safeguard Procedures Report, how many states currently have that is done and complete?
Mr. Chairman, I'm told that all 15 have submitted.
All 15 are done?
Yes,
on that.
and I believe the Federal Exchange has also. Is that correct? Yes.
I would hope that would be the easiest of all of them.
I would also add that we've begun our state-by-state or exchange-by-exchange safeguards reviews literally this week.
Well, that would be one to watch for. Just unauthorized use for unauthorized purposes is one to be able to watch and to be able to track on it. How many, by the way, on all of our states now for exchanges, this is off topic, I'm going to change Mr. Jordan because we've got to go. do all of our states have more than one option on the exchange at this point? Are there states that when they get to the exchange will only have one option when they get to the exchange?
You're talking about insurers.
Yes, ma'am.
We will not have all of that data until the end of July, but we are currently, and I think the state has been in the press, the state that we are most concerned about is Mississippi.
Okay. So, but it looks like all states will have it more than one option on the exchange?
Correct.
Okay. Thank you, Mr. Jordan.
Thank you, Mr. Chairman. I just want to go back to where the chairman was and be clear. Ms. Tavenner, were you consulted at all before the decision was made to delay the employer mandate?
I was not consulted. Now, part of that, in fairness, was I was also on vacation at the time, so I was actually notified while I was on vacation.
Yeah, so you were notified. So you had a cell phone so they could get a hold of you, they could talk to you. You had CMS and you weren't even, they didn't even talk to you before they made this decision?
I think the decision was made with IRS as a predominantly.
Mr. Child, they talked to you? Were you consulted before the White House decided to do this?
No.
Mr. Mulholland, were you consulted?
No, sir.
You weren't consulted?
No, sir.
Mr. Werfel told me about an hour ago you were the expert, and they didn't even call you?
I was not consulted.
Was Mr. Werfel, to your knowledge, was Mr. Werfel consulted?
I believe Mr. Werfel said he received notification on it.
So none of the people who are going to be implementing this were even asked, is this the right move? Was Sarah Hall, to your knowledge, Mr. Mulholland, was Sarah Hall Ingram consulted?
I do not know.
That's amazing to me. You know, Ms. Spear talked about folks who want to throw a train wreck into the, or throw mixed metaphor, throw sand into the gears. I would just remind, it hasn't been Republicans who, and we have Mr. Baucus, one of the architects of the law, calling it a train wreck. We have the president suspending the law without consulting the people who have to actually make it work. Mr. Chow, you made a statement back in March that you hoped the exchanges wouldn't be a, quote, third world experience. So you obviously had some knowledge of and some concerns to prompt that statement. Those concerns still relevant, still valid?
I was speaking before an audience of issuers that I had spoken to before, and it was a poor attempt at humor. So I wouldn't necessarily.
I don't know that it was a poor attempt at humor. It may have been, you know, you may have been a visionary. You may have been a prophet. I mean, this is the fact that they didn't even talk to you is what I think is amazing. You don't talk to the head of CMS. You don't talk to the head of the IRS. You don't talk to the person at the IRS who's actually in charge of the Affordable Care Act office. You don't talk to the technical database expert, Mr. Mulholland. You just decide one day you're going to waive part of the law. I mean, we had the previous Democrat talk about when Medicare was I'd be curious to know if the president at the time Medicare was implemented, if he asked for a delay in the law. Maybe he did, but I don't know about it. This is amazing. But let me ask you one specific question, Ms. Tavenner. In February of this year, HHS System of Records notice includes the following statement. The Secretary, you, along with other appropriate agencies, will establish an appeals process for individuals and employers when eligibility is denied as a result of inconsistencies between information obtained from applicants and enrollees and employers and information and data verified through the exchange. I have no idea what all that means. I hope you can tell me. Maybe you can define what inconsistencies are. Do you have a list of what those may be? You obviously anticipate problems because you're setting up an appeals process. So can you give me some insight into that?
So the appeals process is required in the law, but I'll remind you there's also an appeals process today in Medicaid and CHIP and other programs, because sometimes.
I understand that. Do you have, but I mean specifically, what are you thinking about? Obviously, you think there's going to happen. The law requires you have some kind of appeals process. That makes sense to me. We understand that. What are some of the anticipated inconsistencies?
So I think perhaps people submit information and they get denied and they believe their information was incorrect and they want to bring new information forward, but I'll be happy to get you a list.
So you don't know what the list is. You just use the term inconsistencies because you anticipate there's going to be problems. You anticipate this, in fact, could be a train wreck. You anticipate, in fact, this could be a third world experience.
I do not anticipate that, and we are currently in rulemaking on the appeals process, and the final rule will be out shortly.
Do you think you think everything could be up and running, working on October 1st, and started next year, this law can be fully implemented, working? You think it can all function the way it's supposed to, the way the folks who voted for it designed it to? Do you think that can all happen?
Yes, sir. My background has been...
So if you think that can all work, you would think the administration would call you up and consult with you before they decide to say, you know what, we don't think it can, and we're going to delay part of it. That seems logical to me, doesn't it? Does that seem logical to you that you, the person in charge of it, would be called, would be consulted? Don't you think it makes sense for you to be consulted before a major decision, a major element of the law is simply waived for a year?
The employer mandate rests within IRS.
That's not what I asked. Don't you think it makes sense for you, the head of CMS, charged with implementing this law, don't you think it makes sense for you to be consulted? Because if you don't, then that's scary too. If you don't think as the person who heads CMS, you should be consulted before a major decision to unilaterally just delay part of the law should take place. If you don't think you should be consulted, then I got concerns on that side as well. So do you think you should have been consulted?
I think I've been consulted all along.
Well, no, that's not, you just told me, I got 4 minutes ago, you just told me you weren't consulted. So which one is it? Because you have to tell us what really happened. You can't have it both ways. Were you consulted or weren't you consulted?
I was not consulted. I'm just saying that.
Well, now wait a minute. So then 10 seconds ago, you just said you were.
I'll ask the gentleman to let her answer.
Please let me finish my sentence.
I want you to finish it. I just want you to finish it truthfully because you've told me two different things.
Well, I take objection to that because I've told you the truth.
We can read the transcript.
I would ask the gentleman to let her finish answering.
For the last 3.5 years, I actually started working.
I want you to answer one question. Were you consulted or not? And then I'll let you answer.
Were you consulted? I was not consulted.
Okay. Thank you. Thank you, Mr. Chairman.
And I guess I won't get to finish the
No, go ahead. You can respond.
For the last 3.5 years, I've worked at CMS. I started at the time that the law was actually passed. And I have been an integral part of every decision that's made. In the case of the IRS and the employer mandate, I was not consulted. I do feel like I'm part of the process. Thank you.
No. And by the way, we assume you are part of the process. You have been an integral part of that. That's somewhat the surprise to us. We're trying to figure out where this came from, and it is a major shift in what's happening. And we assume there was some conversation in trying to figure out the whys and the whats with it. And that clarification has not come. We've also written letters to the administration to try to get some clarification. So some of it's not just on you. It's a surprise as well. We would assume that IRS and CMS would be consulted on this process and would be a part of the decision-making. You all have had a very long day. I appreciate you being here. I hope you get a nice, relaxing lunch where it's quiet and to be able to get some time away on that. With that, this hearing is adjourned.
I didn't even talk to him. That's